Welcome to the Committee on Local Government as we start the 2023 session. Let's see. I think the first order of business we should do is, I guess, take the roll and see who's here.
Mr. Chair, you have a quorum.
All right, great. So as is custom for all these committees, we will go down starting with Senator Hackworth all the way down at the end and go down the dais here and tell everybody who you are and who you represent.
Travis Hackworth, Senator for 38th District, and pleased to be here today.
Bill D. Steff, Virginia Beach, happy to be here. And thank you everybody for your early morning showing up.
Good morning. I'm Emmett Hanger, Senator from Augusta County, the 24th Senatorial District.
And I'm Linwood Lewis. I have the 6th Senate District and live on the Eastern Shore.
Good morning. I'm Senator Barbara Favole. I represent the 31st District, which includes parts of Arlington, Fairfax, and Loudoun.
And I'm Senator Janet Howell. I represent the 32nd District, which abuts Senator Favola's and is parts of Fairfax and Arlington counties.
Good morning. I'm Jeremy McPike, representing the 29th Senate District, Manassas Park, and parts of Prince William.
Morning, John Bell. I represent the 13th District, which is Loudoun and Prince William counties. Welcome to all of you that are here today.
Good morning. Ghazala Hashmi, representing the 10th Senatorial District, which is Richmond City and Chesterfield and Powhatan. Thank you.
All right, and just for everyone's information, a little bit of housekeeping here. We have a number of charter bills, as is customary, and obviously in this committee. Senator Spruill is going to be, again this year, the chair of the Charter Subcommittee. We will have a little membership change on that probably, but in any event, I think his plan is, as a matter of fact, I know his plan is to take up all the charter bills, or as many as he possibly can, next Monday at 8 a.m. before full committee, and anything that is non-controversial and doesn't generate any heat or has any problems with it, we'll just proceed from 8 o'clock on to the 9 o'clock committee meeting where we'll consider it as the full committee. Anything that has a little fever, we'll carry it over and see what we can do with it. But again, next Monday at 8 a.m., Senator Spruill, location to be determined, but probably right in here. Also, as is customary, we're going to start off the first meeting of the Local Government Committee for this session with a presentation from Eldon James. Eldon.
30 seconds, right, Mr. Chairman?
Yes, sir.
Thank you, Mr. Chairman. It's a pleasure to be with you. Welcome, everybody. I'm speaking on behalf of the Virginia Chapter of the American Planning Association. You have at your seats a copy of the 2022 edition of the toolkit, as we refer to it. It's meant to be an easy-to-read document that compiles current enabling legislation on land use in the Commonwealth, land use planning. And Virginia's planners, we'll just skip right to the tagline, are essential in supporting citizens of your communities in helping them develop the plans that really reflect the future of their community. With that, I'll leave you with the document. We're happy to answer questions at any time. And I don't see Andrew Clark. I have an autographed copy for him. So,
thank you. All right, another matter of housekeeping for those who may be here for Senate Bill 1111, Senator Hashmi's bill, and 1158, Senator Marsden's bill. Those are going to go at the request of the patron. They're going to go by for the week. So if anybody's here for that, that will not be taken up during this committee meeting. And now I see we do have a patron with us, Senator Ruff.
Thank you, Mr. Chairman. Senate Bill 956.
Yes, sir. Tell us about your bill.
Most every municipality, in large and small, have areas that have fallen in disrepair and often left empty. All of my towns have such buildings. What was once a family business was left with the business closed, family members who had left the community and have no ties there. They're often not interested in maintaining the building, much less investing to improve them. This bill is an attempt to change that equation It's simply a tool that an area could use if and only if the businesses in the district are interested. If they are, the locality would have to advertise and hold public hearings. They would have to have a mechanism to reimburse the district businesses in their real estate tax liability if their tax liability went up by an equal reduction in other taxes such as a business license tax. Any excess money raised by increasing the real estate taxes could only be used in the district to improve the appearance in the district or to help expand those businesses that wish to expand. It's simply an enabling legislation to give them a tool to try to improve some of these small towns, some of these old downtown areas, whether they're small or large.
All right, questions for Senator Ruff? Senator Favola.
Thank you, Mr. Chairman. The locality would have to define the area for these business districts, correct?
That's correct. The way I believe that it would work, they'd have to go to each business and say, are you interested in doing this?
So the
if they
business
had a majority in a particular area, then that would be the designated area.
Follow-up question.
Sure, Senator Favola.
Would the locality then have to identify the business district on their comprehensive plan and advertise it as such so it would be clear to the public and people who may want to develop?
Mr. Chairman, Senator, they would have to go through the entire process of advertising it in public hearing. And that would be a change in the comprehensive plan.
And that would be a change, okay. And a final question,
Sure.
Mr. Chairman. As I read it, I don't think the business district is acquiring taxing authority, but the locality could apply a tax that would then be used to improve the business district.
That's correct.
Thank you, Mr. Chairman.
Any other questions for Senator Ruff from the committee?
Mr. Chair.
Senator McPike.
Thank you, Mr. Chair. Question for the patron about how this interfaces with existing service districts. There's existing business improvement districts as it is. How do these overlap? And maybe that's a question for council of how these mesh. And I apologize, but overall in favor, I just want to understand the impacts where we do have some business improvement districts already existing. We're now implementing this. How do these two complement or complicate our lives?
Mr. Chairman, you're exactly right. It's a question for him. But I have none of those in my area, but the reality is that it does not require anybody to do anything. And if they felt like it was going to be in conflict with what they already have, they would just stay away from it. Now I'll let him answer.
Jeff?
Mr. Chairman, I can see a situation where there could be overlap. Whether that created a conflict would be up for the locality to decide before they implemented this newer, which is basically a service district. So yeah, I can see how there could be overlap with existing service districts.
Anybody else for Senator Ruff?
Mr. Chairman, just one
Senator
more.
McPike.
It might be another question for council is what does this do that a service district can't do under the existing language? And again, it's not to harm the bill. I just want to understand.
We don't use those in our area, so he'll have to answer that.
Mr. Chair, I'm not sure I can answer that in detail. It may go into more economic development tools that the existing service district language doesn't cover, but I'd really have to go back and kind of research that almost line by line to give a better answer to that.
Anybody else? Is there anybody in the audience to speak in favor of Senate Bill 956? Nobody likes it, Frank.
Nobody cares.
Anybody to speak against Senate Bill 956?
Move to report.
Second.
It's been moved and seconded that we recommend, or that we report Senate Bill 956. Open the roll.
Ayes 12, nays 0.
12 people liked it.
Thank you, Mr. Chairman, committee. Appreciate
Thanks,
it.
Senator Ruff. Any other non-committee member patrons here? They're on their way. All right, well, we'll go with, you ready to go? Sure. We'll do Senator Favola then while we're waiting for the non-committee members to show up, and that's Senate Bill 807.
Good morning. So I draw your attention to Senate Bill 807. It's a very straightforward bill. Basically, it allows localities to establish walking trails. They already have the authority to establish hiking and biking trails and horse riding trails. And then it also allows, in cases where a private landowner may give a easement, a public easement to the county, county or locality, it would protect that private landowner from nuisance lawsuits, not from gross negligence, but from nuisance lawsuits. And that protection is already provided if they enter a lease with the county or some other mechanism. This is going to enable, if in fact there's just a public easement granted. It would allow localities to expand or enhance their system of walking trails. I do have representatives from Loudoun County. I put this bill in at the request of Loudoun County. So if you have more detailed questions, I'm sure they would be willing to respond.
Well, let's hear from them then. Let's hear from Loudoun County.
Maybe they're on Zoom. They might be on Zoom. I believe their county attorney was supposed to be on Zoom.
So we got people?
We have several speakers, Mr. Chair.
Lovely. All right. Let's hear from Loudoun County before we hear from just general folks.
Leo Rogers, you may provide your testimony at this time. Leo Rogers, you may provide your testimony.
Leo is the county attorney.
Have we lost him?
Hello, can you hear me?
Yes.
This is Leo Rogers. Can you hear me?
Yes, sir.
Yes, sir.
So
thank you. I'm sorry. I had some technical difficulties on my end. Thank you, Mr. Chairman and Senator Favola. Appreciate this bill being introduced. It does exactly what the senator mentioned. I will say that localities do not have the ability to indemnify and hold harmless property owners. So this would allow localities to interconnect trail systems, particularly in urban areas where HOAs and other organizations are looking for protection against simple negligence liability. Thank you.
So let me ask you this. So was there an incident that prompted this legislation, or are you just trying to dot the I's and cross the T's on liability?
There was not an incident that prompted it. What we're trying to do is interconnect the trail system, and particularly in the urban areas, the larger HOAs, in order to use their trails, want to be protected against liability. So this would allow us to use their trail system through easements, and then those trail systems can interconnect so that the public can go to work or school or other facilities in the nearby vicinity.
All right, thank you. Any questions for Senator Favola or Mr. Rogers from the committee? Yep, Senator DeStefano.
Mr. Chair, Senator Favola. I thought this was a good addition because all you've done is added walking to hiking, biking, horseback riding, and all the other trail systems. So what wasn't covered there was walking. So I thought this was a great idea, great concept, and I fully support this one. I thought this is a good one.
All right.
Okay.
Anybody else in the panel? Senator Spruill.
I came late, Mr. Chairman. I just want to ask my chairman, how should I vote on this?
This is an excellent bill, Senator Spruill. I'm sure you can find your way to voting for excellence.
Bless your heart. Thank you.
All right. Is there anybody in the audience or online to speak in favor of Senate Bill 807?
We have one more speaker, Mr. Chair.
Okay, let's let them go.
Christopher Miller, you may provide your testimony.
Thank you. Christopher Miller, President of the Piedmont Environmental Council. We're very encouraged by this legislation. We're working on a lot of connecting trails, not only in Loudoun, but in other counties and in Albemarle and in the city of Charlottesville. And this issue of liability, the clarification will be a great benefit in negotiations with private landowners. So we fully support the bill and thank Senator Favola for introducing it.
Move to report.
Second.
I'm sorry, is there anybody to speak? Let's adhere to the niceties. Is there anybody here to speak against Senate Bill 807? Senator Stanley, do you have something you want to say?
Mr. Chairman, speak to the bill and maybe an issue. This seems to be, on its surface, a bill about allowing localities to create walking trails. But when you look at really what this is, and there are just some slight changes to the code here that are proposed. But under 15.2.1809.1, we're adding walking trails, but then it also expands it to create a limitation of liability for a private landowner who grants an easement to a government.
That's right.
And that it's not ordinary negligence, it's gross negligence or willful misconduct, which is not the standard for private property owners. So, and quite frankly, Mr. Chairman, members of the committee, and with all due respect to the patron who I absolutely adore and have worked with on bills, I think this is something that should probably be considered by the Committee on the Judiciary. And for those reasons, I would make a substitute motion that we re-refer this to the Committee on the Judiciary.
Mr. Chairman, may I respond?
Senator Fowler.
Of course, I did ask the question of the county attorney and actually for those in DLS, and it is my understanding that this does not protect private landowners against gross negligence, that this is really limited liability protection. But I will ask General Counsel to respond.
Jeff?
Mr. Chairman, if you look on Vines 45, it says in the absence of gross negligence. So it does not exclude gross negligence.
Oh, that's correct, but it raises the bar, does it not, Counsel? In terms of what the standard would be if an injury occurred due to the negligence of the owner who granted the easement, or am I incorrect?
Well, the negligence language is already in the code.
I understand that.
So all we're doing is adding walking.
Or provided by easement, though, right?
Correct.
So,
But Jeff, we do this throughout the code for things like this, don't we?
This is not unique. That's correct.
And I would ask General Counsel, isn't this protection also provided if it was through a property leased or licensed to the county? So in certain cases, they already have this protection.
Yeah, I'm not sure.
It does say, the existing code language does say leased or licensed, and we are adding or provided by easement. So in some respects, we have crossed the Rubicon on that.
That's right. But we've crossed that Rubicon, so please don't.
Well, I'm sure Senator Sorrell will also raise this issue.
I was going to say, Senator Sorrell would have a lot to talk about on this one.
All right, where are we procedurally? Did you make a motion, Senator Stanley?
Mr. Chairman, I'll withdraw that motion and proceed with the motion of Senator Howe.
Okay. Did you get a second? Okay.
Yes.
All right, it's been moved and seconded that we report 807. Open the roll.
Senator Howell, will you vote for me, please?
Ayes 12, noes 1.
All right, thank you, Senator Favola.
First is Senate Bill 1236, I believe. Mr. Chairman, members of the committee, a couple of years ago, we adopted legislation dealing with the ability of localities to adopt ordinances restricting the possession of firearms in certain areas. That was adopted before the U.S. Supreme Court decided the Bruin versus New York State Pistol and Gun Association this past year. And the Supreme Court made it clear that in certain sensitive areas, or has made it clear that in certain sensitive areas like government buildings, like courthouses or other government buildings, their decision wouldn't affect the validity of restrictions on the possession of firearms. However, it pointed out and ruled that a more strict analysis is required for other areas, and it's necessary to look at the historical basis for regulations. And this past year, there have been a number of cases, or these past couple of years, there have been a number of cases that have looked at provisions like the restrictions on the ability to possess firearms in public parks or on public streets. And there have been at least one Virginia court that has ruled that this is an unconstitutional regulation on the ability of persons to protect themselves and to possess a firearm consistent with the protections of the Second Amendment. The Supreme Court has made it clear that the Second Amendment is incorporated and those protections do apply and can't be trumped by state law. So what this bill does is it merely looks at this -915 and takes the public parks, the recreation community centers, and public streets and roads out of the authorization given to local governments to restrict firearms. Now, I will point out in full candor to the committee that the Winchester City case that was decided, ruling that Winchester's ordinances were unconstitutional, went only to little Romanet 2 and Romanet 4 of this provision, held that ordinances adopted pursuant to Romanet 2 and Romanet 4 are unconstitutional on their face. Romanet 3, the court ruled that it was not unconstitutional. So my bill addresses all three. If, however, the committee wanted to adopt a bill that is consistent with and coextensive with the rulings of the courts, it would address only Romanets 2 and Romanet 4, not Romanet 3. I would also point out that just last week, the New Jersey federal court also has acted pursuant to the Bruin case and has struck down broad sections of the New Jersey Code as unconstitutional. This is a very narrow bill that addresses two sections of this legislation that I would submit are clearly on their face unconstitutional and need to be removed.
All right, do we have any questions for Senator Obenshain from the committee? Questions?
Mr. Chairman.
Senator Bell?
Thank you. I have a question, and I think I understand, but I want to hear your take on it. One of the religious organizations in my district contacted me about this bill, and their question was if they had, they were concerned if they had events at public parks and had security, which they normally would choose to do, could the security without this bill be armed? And my read of the areas, lines 52 to 54, I would think they would, but it's a little unclear with the provisions and the items you're addressing. So I appreciate your take on that. Thank you.
Mr. Chairman, members of the committee, and that's a good question I was not prepared to answer, but I think the answer to that, is no, they could not be armed pursuant to current law. particularly if they are private security, if it is police provided by local government, of course they can.
Thank you, Mr. Chairman.
Senator Obenshain, let me ask you, wouldn't it be up to the locality to perform the stricter analysis in the process of adopting an ordinance?
No. I think that the teachings of the court, of the United States Supreme Court, is that the analysis is whether there is an historical basis prior to, or an historical basis for those regulations within a state and within the nation. And the analysis has essentially said that restrictions in public places on the possession of firearms that have a historical basis are restrictions against those with an evil intent to possess firearms in those public places. But the tradition is to permit persons to protect themselves and provide for their self-defense in manners consistent with the Second Amendment. So I would submit that it is a statewide and statewide analysis as to what our historical traditions are here in Virginia, and that has been the rulings of the court.
Any other questions from the committee? Is there any current litigation on this that you're aware of?
There is, well, first of all, I would submit that the Bruin case resolved the issue. There is a case, Winchester, at least one case in which a court has struck it down or has issued an injunction against the enforcement of it. That case is ongoing, but I would submit that this doesn't impact that case as much as it addresses the facial unconstitutionality of these two Romanette provisions of the code.
Is there anyone in the audience to speak in favor of Senate Bill?
Mr. Chairman?
I'm sorry, Senator Bell.
Question: when this bill was originally, when this was changed the last time, did it go to local government and judiciary, or does anybody know the history of where this bill went?
I believe it did go to. It did. I don't think it came through local government.
Yeah, I just bring that up because it seems like there's issues that may need to have a look there.
Is there anybody in the audience to speak in favor of 1236? Mr. Van Cleve.
Mr. Chairman, Philip Van Cleve, Virginia Citizens Defense League. Yes, we strongly support this. Indeed, the Bruin case has clarified that certain areas cannot be banned. And it doesn't matter if there's a police presence like at a permitted event. The Supreme Court was clear on that. And the judge has concurred. And we expect actually eventually, community and recreation centers even are clearly not government-sensitive areas. In fact, they're split out separately in the original law you have in front of you. They had government buildings, and then they split out community recreation because that's people swimming in swimming pools. It's not really a government function. Thank you.
Hey, how you doing? Brendan Mooney, former resident, just moved to Idaho, and I travel out here quite a bit. And one of my concerns is, since I travel about the state, especially for VCDL events, it's hard to keep up on the patchwork of laws, knowing that I also have to keep up with the Idaho laws. We respect the Buren decision, so it's pretty easily understood where, that goes on. But I worry about, especially while going to public parks and other events, maybe with my wife and our soon-to-be child, I don't want to have to get hemmed up for having a firearm on me that I would presume would be okay in one city and going to another. It makes it very difficult to navigate these laws. And I think it would also save the state some money from litigation that will happen based on the Buren decision in concurrence of the historical context of what they mentioned in the Supreme Court case. That is one of my major issues that I think also it is unconstitutional on its face for this particular thing, but just worried about traveling about the state and not knowing what city is okay for me to carry and not.
Thank you.
I'm sorry, ma'am, let me interrupt for just a minute. Where's Senator Obenshain?
Right here.
Senator Obenshain, in the interest of time, you have lawyered yourself into another performance in front of judiciary. So I believe there's going to be a motion made to re-refer to judiciary.
So moved, Mr. Chairman.
And I'm sure, and there's a second. And so we need to open the roll, and the motion is re-refer to judiciary.
Ayes 8, noes 6.
Can I change Senator Favola's votes, which is right here?
Mr. Chairman?
I thought I had you.
Yes, sir. Who is that? Senator D-Staff. Yeah.
I just want to explain our no votes on this side. We believe this is one that should truly be heard here. We heard this here the last time when it went the other way, and we feel that it should be heard here as well, because we believe this is something that we can handle here in local governments and then send to the floor. So that's why the no votes.
Actually, I think Jeff indicated it went through judiciary last time, right?
3 years ago, the amendments went through judiciary.
Yeah. Okay.
We started it here, didn't we, Jeff?
I don't think LAS says that.
Either way. All right, you okay?
In the words of the Bee Gees, I'm staying alive.
All right, Senator Stewart.
Do you want to take my other bill?
Oh, I'm sorry. Yeah, you've got two.
That's
I'm sorry.
okay.
Go ahead.
I'm happy to defer, but
No, go right ahead.
Senate Bill 1246. This bill deals with emergency medical services, and the genesis of this bill and the reason that I took this bill was that undertook to advance this bill is that during the past several years, federal relief has been available to states in form of ARPA and other relief, and a number of EMS organizations have sought to utilize ARPA funds, and because they are not essential medical services, some of those funds have not been made available. This is to, at least my objective in carrying this bill is to qualify EMS services around Virginia for those benefits. Where I live, many of the EMS services are provided by volunteers. I have for 25 years served as pro bono legal counsel for the Harrisonburg City Rescue Squad, which is a 100% volunteer organization with no paid staff, and they were not able to tap those ARPA funds to support their operations during this difficult time. Many localities across Virginia have paid EMS services, but Mr. Chairman, your area and mine, we rely heavily upon the goodwill of people in our communities, and many times our local governments are stressed and may not have the funds, and it is important for us to be able to tap those emergency funds. So that is my goal in carrying this bill.
Questions from the committee for Senator Obenshain? Anybody? Senator McPike, have you got a question?
Yeah, thank you, Mr. Chair. Just more of a technical one, I guess, of how specifically the geographic boundaries issue. There are mutual aid and service agreements and dynamic deployment. There's many other modes of delivery, and how confining it to geographic boundaries, is that a federal requirement, or is there language that would more openly recognize there's different models of service that are volunteer and paid as well?
Well, let me say my understanding of this, and I may need to phone a friend, but my understanding of this is that it doesn't it's not so much a factor as to whether it's a volunteer or a paid organization, but it's the designation of whether it is an essential emergency medical services operation. And the designation of these services as essential is really the core and heart of this legislation, as opposed to addressing either volunteer or paid organizations. And my understanding is it would qualify paid EMS for that kind of ARPA relief as well.
Anybody else on the panel for Senator Obenshain? Is there anybody in the audience to speak in favor of 1246? Ed?
Thank you, Mr. Chairman. Ed Rhodes, representing the Virginia Association of Rescue Squads, Governmental EMS Administrators, Ambulance Association, and the Virginia Regional Councils. By making this an essential service, it enhances the opportunities for access to federal grant funding, such as ARPA, Coronavirus Aid, Relief, and Economic Security, or the CARES Act. Without the federal funding, EMS services must rely on local and state funding for financial support. Because EMS providers are not recognized as essential workers, they have to fight for Tier 1 priority to receive vaccination if there's a limited vaccine supply. If you remember when we first started getting the COVID shots, they had it set up in different tiers. EMS workers were on the front lines transporting patients with what appeared to be flu-like illness, and then when they get halfway to the hospital or get to the hospital, they find out that it's COVID. We were on Tier 3, and we had to argue and fight to get to Tier 1 and also be able to get supplies. So now more than ever, the important function of EMS plays into the public health system needs and needs to be recognized as essential. Localities authorize an EMS agency to operate by resolution or ordinance of the local government. They specify their service area boundaries for the agency. Each local government must have a local emergency medical response plan, and that's actually in the regulations of EMS. The responding interval standard means time and minutes for which EMS agency will comply. The regulation require all designated emergency response agencies to have mutual aid agreements with other DERAs in the locality and localities. The fear of lawsuit is covered in 32.1.111.4:3, which basically exempts EMS agencies from lawsuits. And I'll be glad to answer any questions.
Is there any question from Mr. Rhodes? Anyone else to speak in favor of 1246? Senator Obenshain, let me ask you a question. Explain to me the importance of striking Seek 2 on 18 to your effort.
I've spoken with Joe, and I think I'm okay with restoring that to the bill, restoring that language.
I don't want to do anything that's going to hurt your purpose.
No, I understand.
Yeah.
And I would be inclined to view that as a friendly amendment. And I've told VACO that I'd like to talk further with them before I make a blood oath that I'm okay with that. But and I'd be happy to speak with you, Mr. Chairman, if my view changed. But I think that's fine.
Okay. Is there a motion to on line 18? Okay. All right. Motion is to unstrike Seek 2 on line 18. Let's open up the roll. All in favor? Aye. I think we have a recorded vote on that, don't we?
No, no.
You can do a voice vote? Okay.
Come on, Chair.
All right. I'm a little rusty. All right. And so I think that was unanimous. There were no. Okay. All right. Then the amendment is agreed to. Anybody to speak against 1246?
Second.
Moved and properly seconded that we report 1246 as amended. Open the roll.
Ayes 14, no zero.
There we go.
Mr. Chairman, members of the committee, thank you very much.
Yes, sir. Senator Stewart. Senate Bill 1061.
Good morning, Mr. Chairman, members of the committee. I've got Senate Bill 1061. And what this bill does essentially is change the notice provisions with regard to bond-financed projects. And I was trying to think of a good example, and the last one that I'm aware of that I worked on actually for a county as a client, there was a dam that failed. And the citizens wanted to do a special tax district, and they did, and there was a process for that, and there was notice, and there were hearings, and they ultimately all agreed to do it, and they used bonds to finance the reconstruction of that dam. And so what this legislation would do is it now would allow you not to have to file notice in the newspaper ahead of that financing. That's what the law currently requires. And so it's somewhat redundant in that if you have, and I know Senator Favola has a great deal of experience at the local government level, and so any project that the local government does, you've got typically one or more public hearings regarding the parameters of the project itself. And so the public is well informed and well advised of what's happening. And then in order to construct or whatever it is you're going to do, you would use these bonds. The law currently requires in Virginia that you go through that whole process again of notices in a newspaper for 2 successive weeks and have those public hearings. I've never been to one where anybody showed up because what they cared about was the project itself, not the actual financing of it. Typically, you do that through an industrial development authority. They changed the federal regulations in 2018, and so what this bill does now is it just aligns the law with the federal regulations. You still could put it in the newspaper if you choose, or if the body felt it prudent to do that, or you could publish it on a website or on some other method to give folks notice. And so that's the bill. There may be folks who would like to testify for or against. I don't know why they testify against this, but perhaps there may be some, and I'm happy to try to answer questions if there are any.
Any questions from the committee for Senator Stewart?
Mr. Chairman.
Senator Stanley.
Mr. Chairman, I'd ask the gentleman, such other methods as found on this bill or such other methods of publication as may be permitted by federal law. What categories of publication does federal law permit in these types of instances?
I can't give you a complete list, but I know that a government website is an allowable method. I don't know all of them.
Mr. Chairman.
Senator Stanley.
Mr. Chairman, I'd ask the gentleman also, in our localities where I'm at, our local periodicals, which are the thriving newspapers in the Commonwealth and elsewhere, I think, which our localities rely so heavily upon, and a lot of our residents and citizens read them. It just seems like we're taking that away as a method of publication, because where I'm living, let's say the federal government allows for publication on a website. Not everybody has maybe a computer, but not everybody has, I don't even have broadband where I live in Glade Hill, Virginia. So how would I know if they choose a publication permitted by federal law, but it's not one that I have access to, and this may be an issue or a project that I'm concerned of, especially if you're representing them?
Well, I would suspect that in your jurisdictions, your supervisors would know that. And if they were aware of that, they would decide that it would be prudent to put it in the newspaper. However, again, I don't know why you'd be so concerned about the bonds. You would have already been through the public hearings with regard to the project itself. So you have it runs in separate sectors. First of all, you do the project, and we're not changing the law with regard to the project. If you're building a school or whatever you're doing, you're going to have multiple public hearings with regard to that. It's the actual bonds itself when the locality submits to you would have Davenport, and that's the only one that I know that does them, so I use them as an example. They would come down, you'd discuss it, you'd have a public hearing about it. Nobody really understands what in the hell they're talking about if you want to know the truth when it comes to these bonds. This just eliminates that requirement that you publish it for 2 successive weeks. You have to give 7 days notice now, and you could do it through other methods.
Mr.
But you
Chairman.
could still do it in the newspaper.
Mr. Chairman.
Senator Stanley?
Last question. Yeah, but, when your locality gets into the bonding game to pay for a project, that is the spending ultimately of taxpayer money, which citizens, whether you think they're knowledgeable or not, should be at least have the opportunity of at least to consider and to address their local government. And you would admit, though, that in any program or any publication allowed by federal law could mean anything that could exclude people from getting notice on a very important issue where taxpayer money is about to be expended, regardless of how good or how right or how just the project may or may not be. Correct?
Mr. Chairman, in response to that, I would say most local government officials, and I use local governments as an example, are very responsible. They know their constituents. They know what their constituents want from them, and they would do what they think is appropriate to advise their constituents of what's coming before them. We live in an age now where most people do things on social media, and a lot of this stuff is put out on social media. And it's been my experience now that the things that are broadcast on social media draw more attention and oftentimes more protest than something that's put in the newspaper. But again, this is the second leg of it. You've already had notice and public hearings on the initial project. This is the financing side.
Mr. Chairman?
I get it, Senator Stewart, I get it, and I see where you're coming from, and I understand it's the second phase of it, but I think it's as much of anything else, it's an erosion issue too. I've got the over-under on which one up here says camel's nose under the tent first. So, Senator Spruill.
Thank you, Mr. Chairman. The public hearing concern. I understand what you were saying, that most now, the media, but you still have old folks like me who like to read the newspaper. And you were saying that most local governments respond to their citizens. No. Not all the time. We have some local governments that I wouldn't dare trust. Some. So my concern is that what you want to do, I'm fine. But my concern is that what about the folks who does not use this thing here? Now, here, what I have here, all I know how to do is text. My granddaughter does all my email and stuff for me. I know how to text. That's it. Don't want to use it, but I have to in case you call me. So what about the folks that we're living longer now? We're not going to stay young like this young man here. We're living younger now. I'm 76 years old. So what about folks who really read and want to know what's happening in their local government? No. So are you saying that if you're saying that they can, they can't? I just want to make sure that you do not take my rights away from reading the paper. So when you leave it up to local government optional, they can or cannot, that's what scares me. I want to make sure that probability is there, that I can read in the paper. So would that hurt your bill by leaving in there as far as the paper concerns?
I think that's the bill, but I leave it to the judgment of the committee. They can still do it if they think it's prudent, or they cannot, is essentially what the bill would do.
Thank you.
All right, Senator Hashmi.
Thank you, Mr. Chair. Sorry, my microphone is disintegrating on me. Just a question, I think following up on what Senator Stanley, and I was surprised to find myself in agreement with Senator Stanley on his questions, but our reliance on social media, I think, is a rather precarious one because we understand how social media is a fickle creature and things can be eliminated, deleted without consequence on social media platforms. My question, I guess, is a legal one. If it's published in a newspaper, aren't we then required to keep these as evidentiary affidavits that we can use and have reliable information that can't be changed, that is there, that we can use in future? Isn't it a much more secure and archival process by going through our newspapers?
It is, Senator Hashmi. Well, the newspaper's supposed to send you an affidavit that it was run. Sometimes you get it, sometimes you don't. Depends upon the publication. In order to comply with the law, what I typically do is I'll cut the ad out, place it in the file, because I do a little bit of this stuff and don't always get the affidavit properly. They don't always run it on time. Sometimes when they proof it, they send it back to you and it's not right, and it delays projects. But what you're saying is technically correct under the current state of the law today. That is what you'd like to do, is have that affidavit or cut the notice out and put it in your file to ensure. You wouldn't need that if you did this. You wouldn't have to have that proof because the law now allows you to either do it or do it a different way. So it wouldn't hurt the eligibility or the legitimacy of the funding stream itself.
Senator Bell.
Thank you, Mr. Chairman. My question is going to line 21, the wording reasonably designed. That's kind of what gives me a problem, because it seems like that's really broad, that almost anything could be considered reasonably designed. Was there any other language you considered to make this more restrictive, or was your intention to leave it that wide open?
I really haven't considered any other language. I'm, reasonably open to something. Reasonable is a term of art under the law. I think staff could correct me, but we use it in a great deal of places. The reasonable and prudent man standard. I mean, we use it in the law, and it is defined as those efforts designed to try to do what you're intending to do or something like that. But I'm not married to it. I really hadn't considered anything else.
All right, any other questions from the panel? All right, and is there anybody here to speak in favor of Senate Bill 1061? Yes, sir.
Good morning. My name is Dave Richardson. I'm the State Treasurer for the Commonwealth. I can help clear up a few things. The reasonably designed language is actually straight out of the federal code. So that's the state law has to comply with the federal law in order for the public hearing to be effective. So that language comes straight from the Internal Revenue Code. A couple of other things I think might help to clarify. These types of bonds that are subject to these public hearings are private activity bonds only. They're not governmental bonds. So these are not the public hearing requirements for private activity bonds. Private activity bonds are only bonds that are the obligation of the underlying borrower. Hospitals, private colleges, nonprofits like the Richmond Goodwill or the YMCA, things like that. So it's not governmental money that's being spent on those bonds. Those types of bonds aren't subject to these requirements. So hopefully that'll clear some of that up. The federal law changed in 2018 to essentially recognize that most people aren't reading newspapers anymore. And so most states, Virginia is sort of an outlier right now in that it's the public hearing requirements that applied to these types of bonds were implemented in 1982. So the Virginia statute is sort of stuck with the language that was there in 1982, requiring once a week for 2 weeks publication in the newspaper. The federal law changed in 2018, and most states didn't have the language embedded in their statutes. So in most states, the public hearing requirement is satisfied by publishing it on a website. And the other states that had specific authorizations for newspaper publications, the vast majority of them have enacted similar legislation. So Virginia is sort of standing out as a state that's still requiring the publications. Where it comes into play, and I'm very sensitive to the rural jurisdictions, where it really comes into play. So for example, take a Centera Health System who has they have facilities in 10 or 12 jurisdictions in Virginia, for example, or Bon Secours, or any one of the other big health systems. When they do one of these tax-exempt bonds through a local industrial development authority, they have to publish that newspaper publication in 12 different jurisdictions. And the costs of those publications are not insignificant. You know, they're very, $1,000 a pop easily. So what they're trying to do is to avoid these unnecessary costs. So that's sort of the bigger picture background here about what we're trying to accomplish with this legislation.
Thank you. Any questions from the committee? Senator Spruill.
So the $1,000 pop you were talking about, that those that have 12 or more jurisdictions, $1,000 pop. If we do this, that $1,000 pop, will they pass that savings on to the customer that goes to these facilities? Because some of these facilities are very high. So what are they going to do with that extra money they're going to receive back? Because that pop you were talking about can be a lot of money, as you want to say. They say, with this pop, guess what? I can lower you. When you come to my hospital, to my doctor's office, I can lower the price of what you charge me now. What they can do with that money?
Well, I really couldn't address that. In the big scheme of things, it's not a large number.
Thank you.
But at the end of the day, it's sort of an anachronism that's stuck back in the 1980s.
I was just doing what you were saying. You were saying $1,000 pop. I'm going to say, wow, it's a lot of money. Thank you, sir. I
Well,
appreciate it.
to a Centerra, it's not much money, but to say a Richmond Goodwill or a YMCA or some other nonprofit, a Ronald McDonald House, they have to do these publications too. So it could be more significant given the size of the borrower.
You're a good lawyer. Thank you so much, sir.
Any other questions from the committee? Is there anybody else to speak in favor of Senate Bill 1061?
Mr. Chair, we have a speaker on Zoom.
Okay, go ahead.
You have a person,
On Zoom.
but you don't you have someone?
Well,
I thought you did those
get to
first.
that. We'll get to that.
Oh, I'm sorry. I apologize. Yes.
Go ahead.
Is it Christopher Miller? Is that who you're waiting for?
Christopher Miller, you may go ahead.
Yeah. As someone who tries to track some of these notices, both in local papers and on the internet, my observation would be great if there would be a central location that the state would identify a website where these types of notices could all be posted and we would all benefit from not having to search for 1,000 sites. Recognize the cost of local advertising in newspapers. The problem with relying on social media or the internet is you have to have the right search, and it ought to be a centralized location for both public and private bond issues. Thank you for taking my comments.
All right, that was opposition. Okay. Is there anybody else to speak in opposition to 1061?
Good morning, Mr. Chairman, members of the committee. Amy Perrin-Seibert here on behalf of the Virginia Press Association. I know nobody is surprised to see me here today. I did actually want to respond to a couple of points that came up. I did some research this weekend and expect to have to do. However, I do think that the thing that's important is that we don't have any opposition to changing it from 14 days to 7. That is a change that happened in the federal code. I think that's totally appropriate here, and I don't think we have any objection to that. I will say that while the federal law, it still does say that you can that any state way that you do public notice is perfectly fine to way to do public notice. So if we want to keep it in the paper, we can keep it in the paper, and that's appropriate and in line with the federal law. I think a couple of things that I think are important is that in newspapers in Virginia in 2019, we passed a law that said when it goes in the paper, it goes in the hard copy. Like Senator Stanley says, it also goes on our websites in front of the paywall on the front page, so it's free to any subscribers. Anybody that's not a subscriber can get all the public notices. And actually, in response to the gentleman on Zoom, we also have a website, virginiapublicnotice.com, that is free and compiles all the public notices in the whole state, so that anything that gets uploaded to the paper automatically goes into into that. And it's a searchable database for any public notices. That's local government, that's state, that's regional. They're all in there. And so that's free and available online. We've actually had lots of people that have been using that over the last few years. We did that about 4 years ago. The Press Association did that to, again, just answer everybody's concerns about making sure that it was online and available. Our suggestion today, I think there's other parts of Senator Stewart's bill that I think are fine. We would just, request respectfully that we strike out the lines that take this out of the paper, especially because this sets up an entirely new standard. We've never had anywhere in the code that says in a manner reasonably designed to inform residents. That's nowhere else, and it's really too vague. When we're talking about an official public notice, that legal notice needs to be somewhere that is verifiable, like we said, archivable. It needs to be a place that we can go back and look at. We need those affidavits. We have to keep those at our office, whether they give them to you or not. They're there and available. If anybody challenges whether that public notice was even printed, they can get that, and that hard copy exists in the paper, and we're required to do that by law. There's nothing anywhere in the code that prevents local governments or anybody from posting this on their websites, putting it on social media. They can feel free to put it on Facebook. They can put it on Twitter. They can do anything they want. Nothing prevents them from doing that, but that shouldn't be the state's official public notice. And so, we respectfully ask, if you could, that we would suggest some line item amendments on lines 21 through 23, striking after hearing through publication. That takes out that language, that vague language, and then also strikes the other part that talks about other methods of publication that are permitted by federal law. Again, that's nowhere in the code. That makes it hard for people to know what could be permitted if we're saying something in federal law. So that is also, again, repeated on line 72 through 74 and line 76. And so with that, we hope that you would amend the bill to take those pieces out. Thank you.
Senator McPike.
Mr. Chairman, I guess if we're done with opposition, if there's no one else ready to speak on opposition, I have a couple questions. Mr. Chairman?
I'm sorry, what, Mr.
I just want to make sure we're closing out. If there's no other opposition before asking.
Is there anybody else to speak in opposition to 1061? I hope not. Go ahead, Senator McPike.
Thank you, Mr. Chairman. I would offer those amendments. I know maybe it's not perfectly what the patron wants, but I'm okay with shortening. I think you've stated that there's already a process that does some earlier notification. For this segment, it sounds like getting to 7 days is at least helpful. And so I would offer those amendments for lines, I think it's 21 through 23, after hearing, strike the rest of the sentence through publication. Then line 25, strike, or other such methods of publication as may be permitted by federal law. And then lines 72 through 74, after hearing, strike the rest of the sentence through publication. And I think that, and then line 76 as well has the same language, so it would be striking or other such methods of publication as may be permitted by federal law. And I think that would help resolve my attorney, Senator Spruill's issues from earlier as well.
Jeff, you got all that? Okay. Moved and seconded that we adopt those amendments just put forward by Senator McPike. All in favor, say aye. Aye. Opposed? So you got 14, you went from 14 to 7.
And Mr. Chairman, I move that the bill be reported as amended.
Second. Moved and seconded that we report Senate Bill 1061 as amended. Open the roll.
Ayes 14, no 0.
Mr. Chairman, I agree with Senator Obenshain. Staying alive is good.
Thank you, sir.
Thank you, Mr. Chairman. This is Senate Bill 1014. It's a bill that I'm carrying at the request of Loudoun County, and basically it just amends the restrictive covenants for the use of property for recreation. There's a piece of property in Sterling, Virginia, which I will point out is a very high-cost area. Property acquisition would be very expensive. The county's been able to has the ability to get this property at a reasonable price. They want to make it into a recreational facility park for residents to use. The county's researched it, and as the code is written, would not be able to use it for that purpose without this amendment or this change. So with that being said, it's a fairly simple bill. Basically, they want to be able to purchase property and then build state-of-the-art recreational facilities, football, baseball field, swimming pool, other amenities to serve the residents of this area. It's recreational facilities that are needed in a high-growth area and would do good for the community. If the county acquires it, the county will definitely be investing in the property for the benefit of the residents. With that being said, it's a fairly simple bill. I know the county attorney, I believe, who was on here earlier, Mr. Rogers, is, I think, online and wants to speak to the bill. I'll be happy to answer any questions the committee has.
Senator Sproul.
So this is for Loudoun County, so this will not affect Virginia. This will affect the other Virginia where you live, right?
Mr.
I just want to make
Chairman.
sure it doesn't affect Virginia. This protect North Virginia.
Mr. Chairman, on line 13, it specifically says acquired by Loudoun County, so it goes specifically to Loudoun County. But we'd love for you to move to Loudoun County. I hear that might be in the cards, maybe, because aren't you all state?
Bless your heart. Thank you. Thank you, Mr. Chairman.
All right. Any questions for Senator Bell before we move on to Mr. Rogers?
Mr. Chairman.
Yep, Senator Stanley.
Mr. Chairman, I'd ask the gentleman, so if there is a piece of property that landowners down through the chain of title have placed a restrictive covenant on, which is legal and binding and runs with the land, that Loudoun County buy this piece of legislation, not just for one little piece, but any piece that it decides now is going to be a recreational use that, as they define it, voids everything with regard to that restricted covenant in that chain of title. Is that correct?
Mr. Chairman, I'm going to phone a friend on that one and let the county attorney answer that very lawyerly type question.
I think he's correct, but I'd like to hear what Mr. Rogers' take is on that.
Chairman Lewis, members of the committee, thank you for the opportunity to present to you today, and I want to thank Senator Bell for introducing this legislation. This legislation would only pertain to a restrictive covenant that is restricting the property for recreational uses. And so if the county is going to buy the property from the property owners, which is what we're looking to do here, there are 3 recreational associations who have been maintaining this property for 60 years. They've done a great job, but the equipment, the facilities, they're quite old. So Loudoun County is looking to invest taxpayer dollars to improve these facilities. And the only way that we can do that with the restrictive covenant in place is to try to find a way to eliminate it. There are 3,500 property owners that have an interest in this covenant. It is impractical for the county to try to sue 3,500 people. By the time you figured out through title searches who they were, you'd start the process all over again, spend millions of dollars trying to get that resolved. So this would apply to property covered by a restrictive covenant where the property owners are selling the land to the county so that the county can invest taxpayer money in order to open up the property for all the residents of the jurisdiction rather than those limited by the restrictive covenant.
Mr. Chairman.
Senator Stanley.
Mr. Chairman, I asked the patron, based on this statute that's being proposed in your bill, so if there was a restrictive covenant that said this land shall only be used for agricultural purposes, and Loudoun County decides for itself that it wants to put a park and soccer fields and all sorts of stuff on this land and wants to buy it and knows it has this tool in the toolbox, so it would, by its declaration that it wanted to use this land for recreational purposes, wouldn't it make that private property owner's property with a restrictive covenant that says nothing other than agricultural farming or whatever can be done on this property? This is an awesome power we're giving the local government. It may be just for one little piece of land, we say, but that's how it always starts. But wouldn't you say that if there's any restrictive covenants that limit to agro or anything else that the owners that have passed down through the chain of title have agreed to in that covenant, this gives Loudoun County the opportunity just with a hatchet come in and say, nope, void. Isn't that correct?
Mr. Chairman, what I would say is and probably not so eloquently as you just did, or passionate, I should say. Let me say that these restrictive covenants, the county's intentions are known to the sellers, and frankly, if they don't like them, they don't have to sell the property because they know what they want to do with it. So, and if you look back 60 years when these were originally made, Loudoun County was farmland. I mean, now it's a highly populated area. A significant amount of things have changed since then. And frankly, there's no way of going back in time and knowing what those original intentions were. But to my point, I think the bigger issue is, I'm not going to disagree with you about the power we're giving to change this. However, the landowner could just not sell the property if they don't like what they're doing. And they know full well what they're going to do with the property. And it is, I believe, in the public's interest and will benefit more people with the plans and the changes in the county.
I have a question for Mr. Rogers. Is he still on?
Yes.
Mr. Rogers, on line 15 of the bill, it says, a restrictive covenant that limits the use of the property. I mean, that's kind of open-ended, isn't it? Limits the use?
Where it also states that it's being acquired from a nonprofit recreational association operating the property as a park or a recreational facility. So it is a restrictive covenant that's run with a recreational association for the purpose of either a park or a recreational facility. So that example of, it was limited to no agriculture would not apply to this restriction. It's really supposed to be narrowly drawn. Just that it was going to be a park before, it's going to be a privately operated park, and now what we want to do is make it a publicly operated park.
Well, let me ask you this, and I know you think it's narrowly drawn. I'm not so sure it is, and do you think you could, if say a Senator Favola were to move that this go by for the day, you would be able to restrict it even more?
We could do that, sure, absolutely.
I think that'd be a good idea.
You took the words out of my mouth, Mr. Chairman. I'm a little uncomfortable with the way it's drafted, but I agree with the intent. So with the permission of the patron, I would ask that it go by for the day, and maybe you can come back to us with an amendment.
Absolutely.
Okay.
Been moved and seconded that.
SB 1014 go by for the day, and I assume that's without objection. Okay?
Thank you.
All right, I think we have one more, and it just happens to be mine. All right, I'm going to present from up here in the interest of time and just to get us moving out of here. This is Senate Bill 1187. This was or is a recommendation of the Chesapeake Bay Commission. This is very similar to a piece of legislation that was introduced last year, and it directs localities to consider the adoption of resilient strategies within their comprehensive plans when they do their comprehensive plans review. It does not mandate that they adopt anything, just requires them to consider. It also uses the resiliency definition that we use in that is already encoded in the Resilience Virginia Revolving Loan Fund. It would actually help localities access funding for resilience projects. And I will also point out that we got it through the Senate last year, but it ran into a little bit of a buzzsaw on the House side. And I've talked to the buzzsaw, and we've massaged the language a little bit. So I think we should be fine when it gets through here. Again, this is just to make sure it gets on the radar screen when they're doing their comprehensive plans. Okay. Any questions for me? I'm going to let Barbara, you can handle this. Senator Favola.
Okay. Thank you, Mr. Chairman. Are there any speakers who would like to come forward in favor of this bill? And we're talking about Senate Bill 1187.
Don't mess it up now.
Welcome.
Members of the committee, Jay Ford, Chesapeake Bay Foundation. I know when we got a good thing, so we support the bill, and we hope you'll support it as well.
Thank you.
Chris Lamb, Virginia League of Conservation Voters. We also support this bill.
Mr. Chair, Pat Calver, Virginia Conservation Network. We're full support of your bill.
Okay. Is there anybody on Zoom who would like to speak in favor of this bill? If so, would the clerk let them into the platform?
Mr. Miller, you may go ahead.
This is Chris Miller from the Piedmont Environmental Council. We support the bill.
Thank you. Is there anybody in the audience in opposition to the bill? Is there anybody on the Zoom platform in opposition to the bill?
We have none.
Thank you.
Second.
Okay. Motion has been made to report and seconded. Will the clerk please open the roll?
Ayes 14, no zero.
Your bill reports, Mr. Chairman, unanimously.
Thank you, Senator, for voting. Docket, here I come. All right, I believe that's all the bills we have on our docket for today. Again, remember, Senator Sproul.
Yes.
So, Charter Subcommittee on Monday at 8, is that correct?
Yes, sir. Is that what we usually have? Yes, sir.
All right, and so that will be in this room Monday at 8 o'clock, next Monday at 8 o'clock for our, as many charters, all charters, if we can get them on there, but as many as we can. With that, we are adjourned. Thank you all very much.